Essentials of valid contract. There are various elements of is essential for to become the valid contract. Offer and acceptance, free consent, contractual capacity, lawful consideration, lawful object, agreement not declared void, possibility of performance, certainty of term, legal relations, legal formalities. The first one, offer and acceptance. There must be two parties to an agreement. That is, one party making the offer and the other party accepting it. Offer and acceptance must be both lawful. It must conform to the rules laid down in the Indian Contract Act. Agreement is the result of offer and acceptance. Person who offers is called the offerer. Person who accepts the offer or proposal is called offeree. For example, A say to B that he will sell his cycle to him for rupees 2000. This is an offer. If B accepts this offer, there is an acceptance. Next one, free consent. It is another essentials of valid contract. Consent means that the parties must have agreed upon the same thing in the same sense. For a valid contract, it is necessary that the consent of parties to the contract must be free. Free consent does not exist when it is obtained by fraud, mistake, coercion, etc. For example, A compels B to enter into a contract on the point of pistol. It is not a valid contract as the consent of B is not free. Contractual capacity. The parties to the agreement must be competent of entering into a valid contract. According to section 11, a person is said to be competent if he is of age of majority, of sound mind, and not disqualified from entering a contract by any law. If one of the parties to the agreement suffers from minority, madness, drunkenness, etc., the agreement is not enforceable at law. For example, Mr. M, a person of unsound mind, enters into an agreement with the person S to sell his house for rupees 2 lakh. It is not a valid contract because Mr. M is not competent to contract. Another example, Mr. A, aged 20, promises to sell his car to Mr. B for rupees 3 lakh. It is a valid contract because A is competent to contract. Lawful consideration. Consideration is something in return. It may be some benefits to the party. Consideration has been defined as the price paid by one party for the promise of the other. An agreement is enforceable only when both the parties give something and get something in return. Lawful object. The object of the agreement must be lawful. The object for which the agreement has been entered into must not be a fraudulent one. Fraudulent or illegal or immoral or opposed to public policy, or must not imply injury to the person or property of another. Every agreement of which the object or consideration is unlawful is illegal and therefore it is void. For example, A promised to pay B rupees 5,000 if B beats C. The agreement is illegal as its object is unlawful. Agreement not declared void. An agreement to become a contract should not be an agreement which has been expressly declared void by any law in the country, as it would not be enforceable at law. Under different sections of the Contract Act 1872, the following agreements have been said to be expressly void. That is, agreements made with the parties having no contractual capacity, for example, minor and persons of unsound mind, and agreements made under a mutual mistake of facts, agreements with unlawful consideration or objects, agreements whose consideration or object is unlawful in part, agreements having no consideration. Possibility of performance. The valid contract must be capable of performance. An agreement to do an act impossible in itself is void. If the act is legally or physically impossible to perform, the agreement cannot be enforced at law. For example, Mr. A agrees to share with B 50% of treasure if created by magic. The agreement is not enforceable. Certainty of terms. For a valid contract, the terms and conditions of an agreement must be clear and certain. The agreement must not be vague, uncertain, or ambiguous. For example, Mr. A promised to sell 20 books to B. It is not clear which books A has promised to sell. The agreement is void because the terms are not clear. Another example, Mr. O agreed to purchase a van from Mr. S on hire purchase terms. The price was to be paid over 2 years. Held, there was no contract as the terms were not certain about the rate of interest and made of payment. Legal relations. The parties to an agreement must create the legal relationship. Agreements of a social or domestic nature do not create the legal relations and as such cannot give rise to a contract. It is presumed in commercial agreements that parties intend to create the legal relations. For example, father promises to pay his son ₹500 every month as pocket money. Later, he refuses to pay. The son cannot recover as it is a social agreement and does not create any legal relations. Another example, Mr. A offers to sell his watch to Mr. B for ₹200 and B agrees to buy it at the same price. There is a contract as it creates the legal relationship between them. Legal formalities. The agreement may be oral or in writing. When the agreement is in writing, it must comply with all the legal formalities as to attestation, registrations if it is required for land. If the agreement does not comply with the necessary legal formalities, it cannot be enforced by law. It is essential for the validity of a contract that it must be in writing, signed and attested by witness and registered if so required by the law. For example, Mr. A verbally promises to sell his book to Mr. Y for ₹200. It is a valid contract because the law does not require it to be in writing. Another example, Mr. A verbally promises to sell his house to B. It is not a valid contract because the law requires that contract of immovable property must be in writing.